Hi, good morning. So today we'll start with the next lecture, and subject is private international law. Uh, Last class I've done with the introduction of the private international law. I said how private international law came into existence, what is choice of law, what is domicile, lex fori. So there must be some questions regarding private international law. So today I've thought to clear the doubts, and today I also thought of dealing with the nature and scope of private international law, the difference between private and public international law, how is it seen in the international arena with some examples and case laws, and how is it different, the nature is different in different countries. So I hope you will have a quite understanding regarding the knowledge of private international law after the end of this lecture. So here we start. So as we know that conflicts of law or private international law or international private law. So these are the three names of private international law. So generally private international law, the name we know is being said in India, Pakistan, Bangladesh. Conflicts of law is being used in countries like USA, Canada, England. So there are a variety of names. We must not get confused regarding the name. So private international law is also known as conflicts of law and also international private law. So what does it mean? Conflicts of law or private international law, both terms are used interchangeably, concerns relation across different legal jurisdiction between person and sometimes also companies, corporation and other legal entities. Private international law or conflicts of law is that part of law of a state which comes into operation whenever there is a dispute before a court which contain a foreign element. As I said that private international law comes into existence when there is a legal difference between two individuals and they are situated at two different countries. Only then, and it is between two private individuals, not public individual. That's why it is known as private international law. Now we come to the definition part. The private international law is the part of the law of every state which deal with cases having a foreign element. So this is very important that all the cases have been or have a foreign element in it. Next, the law of the place where a transaction physically takes place or of the occurrence that have arisen to the litigation, that is known as the lex loci actus, will often be controlling law selected when the matter is substantive, but the proper law has become more common choice. So this is one of the most easiest example that I have thought of incorporating into it. Next we come to the nature and scope. So private international law, or as we know the conflicts of law, is that part of law which comes into operation whenever the court is faced with a dispute that involves a foreign element. Foreign element means any fact relevant to the issues involved in the proceedings which has a connection with the territorial unit other than the territorial unit where the court is dealing with the proceedings. Example of foreign elements, it can be parties, maybe a citizen of a foreign country or domicile in a foreign country. Now you must be asking how it is possible. So let's take an example. We take the case of Akshay Kumar. He is a citizen of Canada, but he is domiciled in India. So that can be one of an example of foreign element where a party is a citizen of one country and it is domiciled in another country. Next we move on to the subject of the private international law. So there are two main subjects of private international law. That is private law relation associated with foreign law, or private law relations burdened with foreign element. So this two things is very important. Next, what are the relations of the private international law? So how it is related, what type of cases are there in private international law? Now private international law covers these cases. Number one, property and associated non-property relations between private person. There may be anything related to property or non-property relations. Civil law relations, any civil matters can also be a part of private international law. Family law relations such as divorce, marriage, adoptions, they come under the family law relations. Next we have labor law relations such as employee or laborers working for an MNCs, they all come under private international law. Land law relations, trade relations, and also monetary relations. So these are some of the subject area that covers the private international law. Next we move to the rules under private international law. So if the court doesn't have jurisdiction, it will not go into the matter. If there is a foreign judgment, it is for the court to decide whether it should be recognized and enforced. If it decides to recognize and enforce a foreign judgment, so these are the rules that all the courts have to abide under the private international law. So first of all, they will look for the jurisdiction, which court has the perfect jurisdiction. Then they will move on whether it should be enforced or recognized. Now if it decides to recognize and enforce a foreign judgment, then they will have the right to proceed with the case. Now we have the two-stage process. What does it say? Courts faced with the choice of law issue have two-stage process. Number one, the court will apply the law of the forum, which is also known as lex fori, to all procedural matters, and number two, it counts a factor that connect or link the legal issues of the laws of potentially relevant states and applies the law that have the greatest connection. So these are the two things. So first is that the court will look the law of the land, which is also known as lex fori, and then they will have to connect the matter, and then they apply the law which has the greatest connections with the party indulged. Next we come with the characteristics of PIL. So it is applied when the dispute before a court contains a foreign element. So this is very important. So a case must have a foreign element. Other than a foreign element, it cannot be tried under private international law. So PIL is essentially a system of indicating choice. It does not lead to any final decision. Okay, it is among the party. So here we can say that it is a drawback, since it is upon the party to determine whether they will abide by the law or they won't. So this is a little disadvantage or a drawback, we must say, of private international law, since it is not compulsory or mandated to a private individuals. So this, it might be said that it doesn't have a binding effect. Now binding effect is only available when the parties of the case, they abide by the law. Only then it becomes a binding effect. Next, PIL is based on committee, convenience and justice. So committee is between, it means between the two parties. Convenience, the convenience means which court is the most appropriate for the parties, and justice is the ideal of every case. Now we have the basic principles of PIL: choice of jurisdiction, we have the choice of law, and recognition and enforcement of foreign judgment. So these are the basic principles of PIL. Next we have elements. Two elements are fundamental in order to determine a private international social relation, which have the internationality and horizontal relations. Now we briefly read both these aspects, both these elements. Now, cases, there is internationality of PIL. What is it? The law of the nationality is meaningless. The judges throw himself back on the domicile of the origin and thus determined the rights of the parties by the legal system, which is neither the national law nor the law of the domicile as required by the private internal law. So the judgment seems to be superfluous. Next we have horizontal private relation. So this is a private international law social relation. That is, Germany through a public offer of a contract buys to an American company Y and 20,000 of chairs as a part of a program of the improvement of old people's house in the country. Germany sues the American company for the breach of contract. So this is known as the horizontal private relations. Now we have the discussion, or we can say the difference between PIL and public international law, the private and the public international law. Now what does it say? Private international is a part of the law of state, but public international law is the law which is recognized by different states internationally. Next, PIL of one country may differ from another country, but public international law is same in different countries. So this is very important. Next we have PIL is domestic law of one country. On the other hand, public international law is in its very nature universal. PIL does not give any solution, but public international law gives solution. So that's it for today. I hope you like this class, and I have a strong belief that you have understood many things of private international law. Hope we will meet soon in the next lectures, where we'll study the different aspects. We'll study the lex fori, lex causa, that are the importance which are importance of the private international law. So I would request everyone to stay safe and be good to your families. Thank you very much.